What's up, y'all? This is your boy, the non-lawyer, coming back again with yet another video on this whole fiasco with Cardi B and Tasha K. How could Tasha K get rid of this debt? And I actually found a way that Tasha K could actually use, or a technique that she can use to reduce the debt. And it's kind of like a little known dirty little secret that a lot of people overlook. Now, of course, an appeal is one route to go about it, but there's actually another little technique, or maybe technique is the wrong word to use, but there's another path. There's another path. Now, this path doesn't eliminate her chances of appeal. It just gives her one little extra option for trying to reduce this debt. But right? Again, I have found a way that a path that she can take that's going to allow her to reduce that judgment, right? Allow her to reduce that judgment to something. What I made this video for is that there's other options, right? There's other options out there. There is a way that Tasha K can actually reduce the debt. There's another process that she can use, but she has to act quick. She has to move quickly. And she has a chance of reducing that debt, right? So right before me, let me see what page I'm on so I don't forget. 83. I'm on page 83. But just so you know, the facts, nothing more, nothing less. Federal Rules of Civil Procedure. And again, I was on page 83. And we're going to talk about how to get rid of, how to reduce, right? Not necessarily to get rid of, but we're going to talk about how to reduce that $3.8 million, or round it up to, $4 million. How to reduce that, right? Because that's a lot of damn money, right? And honestly, I think Tasha got it. I think Tasha got that money in the bank and is just waiting. And she's just buying time, and she can just go ahead and pay that out. Most people don't believe that she's a millionaire, but I actually think she is a millionaire already, right? So she already got that money. And if she don't have it, then she know that she can get it in a reasonable amount of time. So she not worried. People are asking, well, why does Tasha K look so calm, and why is this not driving her crazy? It's because she got the money already. Damn, where was I? 1 second, people. 1 second. Come on. Rule 54. I was on 59, 57. All right. So Tasha K can go in back to court, and she can say, bitch, I want a new trial. Rule 59, new trial, or altering or amending a judgment. And this is some tricky shit. This is some very, very tricky stuff, because what I'm about to tell you, or what I'm about to show you, is something that a lot of people don't think about. Now, I've watched lots of lawyers talk about this case, and I've watched lots of lawyers talk about the options for Tasha K, and none of them have basically thought about this, right? I'm not saying that they don't know, right? And they're just on YouTube and they're just talking. So maybe for whatever reason this didn't come up, but I promise you, what I'm about to show you is a way that Tasha K can go in and she can ask for a new trial, or she can alter or amend the judgment. And this is some sneaky shit. I promise you, this is some sneaky shit, right? So basically, we're just going to read some of this, because we're not going to read it all, but this rule, basically, Rule 59, provides a vehicle for Tasha K to go back to court, ask for a new trial, or alter or amend the judgment. Now, the tricky part of this is that I don't want you to get stuck on the new trial, because people probably saying, oh, if she get a new trial, she's just going to lose anyway. Anybody finna find her not guilty? So that's probably what you're thinking, but it's not really about the new trial, right? So let's just read some of this, right? So in general, grounds for a new trial. The court may, on motion, grant a new trial on all or some of the issues and to any party as follow. And it goes, after a jury trial for any reason for which a new trial has hereto been granted in an action at law in federal court, right? And then it goes, further action after a non-jury trial. We ain't gonna read that. And then it talks about the time to do this, right? So there's a small window of which you can do this. For the most part, it's 30 days. When a motion for a new trial is based on affidavits, they must be filed within the motion. The opposing party has 14 days after being served to file the opposing affidavit. The court may permit reply affidavits. New trials on the court's initiative or for reasons not in the motion no later than 28 days after the entry of the judgment. The court, on its own, may order a new trial for any reason that would justify granting one on the party's motion. So it's like they don't want to tell you. What I notice about the federal rules is that it basically gives you the basics. But if you look at some of the wording, you'll see that there's much, much more to what they're revealing to you, right? So it says the court on its own may order a new trial for any reason that would justify granting one. So the first question is, what are the reasons that would justify granting a new trial, right? What are the reasons for granting a new trial? What are some of the reasons Tasha K can go back to court and say, bitch, I want a new trial? What are the reasons? Right? So we're going to get into one of them. We're going to get into one of them. It's a very good one. And I'm going to give it to you in a quick hot minute. Then it goes, after giving the parties notice and opportunity to be heard, the court may grant a timely motion for a new trial for a reason not stated in the motion. In either event, the court must specify the reasons in its order, right? So the person, Tasha K, would have to go in and she would have to ask for a new trial, and then she would have to give a reason for the new trial. And I'm going to give you that reason in a second here, right? And then it goes, motion to alter or amend a judgment. A motion to alter or amend a judgment must be filed no later than 28 days after the entry of the judgment. So for the most part, you got 28 days to go in and ask for a new trial, or you got 28 days to alter or amend the judgment, right? And there's also another mechanism or another vehicle for getting relief from judgments. And this is Rule 60, relief from a judgment. And basically, if there was clerical mistakes, so on and so forth, you can get relief from that. And grounds, there's another reason, grounds for relief from final judgments, orders, or proceedings on a motion. Just terms of court may relieve a party or its legal representation from a final judgment, order, or proceeding for the following reasons, right? And then it goes through all these lists: mistakes, newly discovered evidence, fraud, the judgment is void, the judgment has been satisfied, any other reasons that justify relief. This is actually a tricky one right here, because it just kind of opens the gate. If there's something extraordinary, or if there's a situation where there's something extreme, right, that would justify you going in to get a new trial. But I think for the most part, in order to use this one, six, what is this, B6, it has to be something extraordinary, right? And then timing and effect of the new motion. Uh, Rule 60B must be made within a reasonable time for reasons 1, 2, and 3, and no more than a year. So you have a larger window to go in and basically, what is this, ask for relief from the judgment, right? So up to a year, right? Other powers to grant relief. This rule does not limit the court's power to entertain an independent action to relieve a party from a judgment, order, or proceeding, so on and so forth. So anyway, let me get back on point, because I kind of got off point, but I just wanted to show you guys that you can get relief from a judgment, or you can ask for a new trial altering or amending the judgment, right? So Tasha K can go back to court. Tasha K can say, you know what? This is too much goddamn money for me to be paying some goddamn Cardi B over some silly ass video I did on the internet. It's too much money. It's too much money. And most importantly, I can't even afford this shit. I can't even afford this shit. And as a result, the jury made a mistake. The award that the jury gave Cardi B is excessive. And because it's excessive, god damn it, I want a new trial. Now that sounds like a bunch of bullshit, don't it? Sounds like a bunch of bullshit, but let me show you something here. So I'm looking at a Columbia Law Review, right? This is pretty old, so it's dated. I'll give you that. But it talks about something called a Remittitur, right? A Reminitor, right? And essentially, what page am I on? 302. Essentially, a Reminitor is when you go back to court and you basically say this is too much. You know, the jury awarded the plaintiff too much goddamn money. I can't pay this shit. Right? So you go back to court and you say that, and you give the plaintiff two options. They can either have a new trial or they can reduce the judgment. Plain and simple. Plain and simple, right? So just so you guys know, I'm not on any bullshit, right? You can obviously Google Remittitur yourself, right? You can Google Remittitur yourself and you can read what it says, and you tell me. You tell me if what I'm giving you is bullshit. You know, people know I don't bullshit anyway, right? I'll let you know when I'm using my own theories or my own opinion, and when I'm giving you facts. And right now I'm giving you facts, right? So it says the origins of a remittitor practice in federal courts can be traced back to the justice's story of 1822 circuit court decision in Blunt v. Little. The plaintiff received a jury verdict of $2,000, which was a lot of goddamn money in 1822. I can't even imagine how much that is in today's money. I would probably say something like probably $500,000, maybe. I don't know. Anyway, in an action for malicious prosecution, and the defendant moved for a new trial on the ground that the verdict was excessive. Right? So let me read that again. The plaintiff received a jury verdict of $2,000 in an action for malicious prosecution, and the defendant moved for a new trial on the ground that the verdict was excessive. After citing two cases in support of the proposition that a new trial could be granted on the ground of excessive damages, Justice Story noted, if it should be clear, I'm sorry, it should be clearly, I'm damn, I can't even rewrite. If it should clearly appear that the jury have committed a gross error or have acted from improper motives or have given damages excessive in relations to the persons or the injury, it is as much the duty of the court to interfere to prevent the wrong as in any other case. Without further citation or authoritative support, he continued, I have the greatest hesitation to interfere with the verdict, and in doing so, I believe that I go to the very limits of the law. The cause should be submitted to another jury unless the plaintiff is willing to remit $500 in damages. So basically, what the judge is saying is that, look, you got this judgment for $2,000. It's a lot. It's really out of my hands. The only thing I can really do is just send this shit back to another jury for a new trial, or you can reduce the judgment by $500. Right? You can reduce this shit by $500, and then we just say it's $1,500, and call it a day. Bob's your uncle, right? So that's it. So all basically, and then did my shit freeze up? So all Tasha K has to do, my computer's acting funny. It is acting funny. Don't do this to me now, you motherfucker. Why freeze up now? Why? Why would you freeze up on me now? So yeah, that's basically it. The only thing Tasha K has to do is go back to court and just say, yeah, Judge, I can't pay this. I cannot pay the you got look, I don't know who you think I am, but here are my tax returns. Which is kind of funny because Todd, the allegations out there is that she hasn't paid any taxes in over 3 years, but she can just say, look, here is what I've been making from YouTube. Here's is what I've been getting from Pangea. I cannot afford this. I'm only getting something like 150 a year off all this shit. I can't afford it. So we gonna I don't know what you want to do. We're gonna have to either have a new trial or we're gonna have to reduce the amount of money that you trying to get out of me. You choose. You choose. Either reduce the award or we can have a new trial. You choose, goddammit. And then we talk about the procedural steps to a remittance. The trial court Remittitur device is employed only in cases tried to a jury. It usually arises when a losing defendant moves for a new trial on the ground that the damages awarded by the jury are excessive, or for a new trial in the alternative for a Remittitur, right? Basically giving you the option to reduce the damages or we have a new trial, right? If the trial judge finds that the verdict proper, he denies a motion and enters the jury's verdict as a final judgment. If the judge deems the award to be excessive, he can grant a new trial. Conditions upon the refusal of the plaintiff to remit a portion of the jury's verdict or grant a partial or complete new trial. Right? So that's the gist of this video. Right? That is the gist of it. As you see, and I'm coming to you with the facts. Again, I'm not a lawyer, but goddamn it, I can read, motherfucker. So I'm coming to you with the facts. Nothing more, nothing less. Right? Tasha K can go in, file a Rule 59 motion, file that motherfucker, and say, I want a new trial or I want to alter or amend this motherfucking judgment because it's too much money and I can't afford this shit. So what you want to do? What you want to do? We can have a new trial or you can reduce this motherfucking $3.8 million down to some shit I can afford, 800,000. What's up? Now, but you know what? I wouldn't approach it like that, right? I would still file the Rule 59 motion for the new trial, altering or amending the judgment. But once I file it, I would go over to Cardi B and say, look, you know what, you won. And I would say, you won. What I did was wrong. I took the videos down. Now we're in a situation where we're just going to really waste more time and money because at the end of the day, I can't afford this. What you trying to get out of me, I can't even afford. So either you going to put me in a situation where I'm just going to have to live under a bridge and eat cat food for the rest of my life, or we can just go ahead and agree to a reasonable amount, maybe 800,000, maybe $1 million or something. We can agree to that, and I can just start cutting them checks, and we can just both move on with our lives. I'll make a video publicly apologizing to you and saying what I did was wrong, but we got to move on from this. You got to reduce this shit because this shit is killing me. This shit is killing me, right? And then when you put in your motion, you make it clear what your income is. You make it clear that you can't afford this. Or in your motion, you can just say it's excessive. You ain't even really got to talk about your income. You can just say, you know what, this is an excessive amount of money. And you can also, one of the things I noticed some of the lawyers, some of the actual real lawyers were saying is that Cardi B never proved some of the damages, like the emotional distress. If don't correct me, I'm sorry, correct me if I'm wrong, but some of the lawyers who actually talk about this case were saying that she never proved damages, right? You know, so you throw that into motion. You can say the award was excessive, and Cardi B never even approved the emotional distress, the medical part of it, where she allegedly, not allegedly, where she got treatment from a psychologist, right? She never proved it, right? So you throw all that stuff in motion, you make it really persuasive and smooth, and then you file that shit, and then you go and you talk to Cardi B and try to kiss her ass and just make all this stuff go away. But look, that's it for this video. Let me know what you guys thought. Do you think that this is a viable option for Tasha K? I'm sorry. I'm trying any and everything. You can kiss my black ass. I'm filing a Rule 59 motion. If that don't work, then I'm filing a motherfucking bankruptcy adversarial proceeding. I'm going to go to the motherfucking law books and I'm going to dig deep and find a legitimate argument, a legitimate good faith argument for overturning section 523(6)(c). And if that shit don't work, goddamn it, I'm gonna appeal. I'm sorry, I ain't paying that shit. Fuck y'all. But anyway, look, let me know what you guys think. Do you think any of this stuff that I actually spoke about is on point? Would you try, right? If you were in Tasha K's situation, would you try to file a Rule 59? New trial, alternate amending judgment? Would you try to get that shit reduced through a Reminitor? Would you try to still file that adversary proceeding? And would you appeal? Right? Put yourself in Tasha K's shoes. Even though everybody knows the average person isn't stupid enough to do the shit that Tasha K did, but what if you were in her shoes? Would you try these things? What do you think about the information I delivered to you? And most importantly, if you like this video, please share it on Twitter. Please share it on Facebook or wherever. Please share it. That's it for this video. Like, share, and subscribe.